This sitting is resumed. Prior to the suspension for lunch, this honorable chamber was debating Order 6 on the order paper. To that we shall resume. Honorable Mr. Michaelis.
Thank you, Mr. Speaker. I want to take a completely different perspective on these family issues. I've heard a long discourse on the family law as it relates to dissolution of marriages, the two different stages, decree, nisi, and absolute. I've heard about counseling. I've heard about matters within the family law courts before the judge. But the irony of this is that the majority of families that exist in Barbados, their lives hold no relevance to none of those tenets that were advanced in the discourse this morning about the Family Law Act. Most of us are offsprings of the matrivocal family and the matriarchal family. We are, a large percentage of us are from single-parent families. Now, I know that the law within the Commonwealth, grounded in British values, do not include visiting relationships. And probably most of us might be the output of the reproductive system that give rise to persons who are from households where the father visited for a number of hours and then disappeared and returned the following week again. And if you have any understanding of the history, again, because you have to understand why we are here, and why we also demand that you show the same level of dignity in respect to relationships that came up outside of the family law relationships, that is marriages, union other than marriages, and that has its own definition and limitations as well. And what we might call a union other than marriage as a layperson is certainly the law itself don't fit into the definition of the law. You have to be living under the same roof, I think, for about 5 years as man and woman. Never at any time swear to any vows of any matrimonial commitments, and you will still be considered as a person living in a union other than a marriage. And the law itself, there are a number of subjective views in the laws, and lawyers, as far as the judiciary, hold to the view that they should function on need to give certain rights and feelings of dignity. They should function within the framework of the two definitions, which is the union other than a marriage and a marriage itself. Now, I believe in the subconscious mind, that has given rise to a sense of feeling of inferiority and a lack of dignity. And that is why a few years ago, we were accepting and saying to each other, "You're a bastard." People who were perceived as bastards because they were not products of any of the two unions. And the last one sneaking to the law in the latter part of the first half of the 20th century, the union other than a marriage. And persons who are engaged in those unions are recipients of material and monetary benefits, not just their children, when the relationships are separated. So you hear about dissolution of marriage and persons filing for special matrimonial rights and property and things of that kind of maintenance. The law did not dignify the working class relationships. That's why you know the definitions in the heads of the academics is completely different to the definition in village. They did not recognize the other unions, in my view, if you want to put it quote unquote, as genuine unions. And therefore, the only provisions that are very clear to the average man and woman is the provisions that fall under the Maintenance Act. So you tell a working class woman, well, you got certain rights before the court. This man is the father of your child. The child is under the age of 18. The child is still studying even after he exceeds the age of 18. And therefore, the court will award you some monetary benefits. So you get maintenance for the child, and you probably get additional finance for the child so the child can complete his education and things of that nature. But under that Family Law Act, that spouse is not given the privilege, even if she separates from the man for 6 months, and she goes back into the relation and then separates again, and she wants rights to the property of that man, like the ones who are dignified because the business is conducted in the Supreme Court by a judge with a wig. She doesn't have any rights to the property of the man. She can get rights to cover the maintenance of the children, but after living with that man for 8, 9, 10 years, and they separate the relationship because he might not be living consistently in the house with her. As I said, he has a house of theirs, he visits, he supports the entire house, but he now accumulate lots of wealth, and then the only thing that is left for her is memories. And the children might get maintenance provided that they are under a specific age. I believe, sir, that we need to be at this stage. As we make amendments, yes, that is all right, but if we make amendments, we also have to take into consideration the thinking of the society, how the people in the village feel about these relationships, the separation of these relationships, what they feel is a family. What they feel is a family. And why the law cannot dignify relationships, visiting relationships, where even if there are 2 or 3 children from different fathers. The village believe, and I'll tell you this now, from observation, and it can't be anything else but observation. It either has to be obtrusive or inobtrusive. From observation, some of the strongest bonds that you can see is when you have sometimes 3 or 4 children from different fathers but growing up under one mother. And that reminds me of Edith Clark's text.
My mother
Who fathered me. And I know that you'll be fully aware of this, Mr. Speaker. Why should we continue to make amendments to Family Law Act, but keep the Family Law Act separate and distinct from the Maintenance Act? It needs to be explained. It needs to be explained. The law itself needs to be explained. And it's because those sociological analysis of a Caribbean environment, especially by persons who preside over cases of this kind in relation to those unions that are not included, our judiciary need to be trained in the Caribbean. There must be something called Caribbean thought. There must be something called Caribbean jurisprudence. Why should a judge, as I heard here, why should a judge have to wait on a welfare officer to make an assessment? A welfare officer don't make an assessment over any union that is a union in a marriage. You don't send a married woman. I never talk about the gender, the way, although we talk about equality within the law itself, the reality is that all the examples that most of us can, when a site is when these relationships break down, they tell you what the benefits of the wife is supposed to be. And they tell you that all equal in the eyes of the law, this is how it should be divided. That a woman could also maintain, could also give maintenance and matrimonial benefits to a wife too, to a husband, that a wife gives to a husband. But I will have to ask you this, sir. How many cases you can cite in Barbados or in the Caribbean where the property of a female has been divided and the man got great rewards out of that? It is just like how men got to struggle every day, and I'm not putting any case for any specific gender. Men got to struggle every day as the law stands to at least have the right to see a child for one day. And then sometimes the female don't even respond favorably. Although the court said you have to let him see the child every Saturday, he will come for the child at 9 o'clock and he can come back at 6 o'clock. The law, the person will go back to court 50 times and the judge, or the magistrate, because we're talking to people in the lower court, the magistrate will say the same thing every time. So those relationships, now we talk about contentious and non-contentious relationships, those relationships, because of lack of clarity, lack of decisiveness, lack of an understanding of who we are, lack of the law not being refined enough to deal with all realities. And all realities derive from, not because we are beasts, not because we don't have any social conscience, not because our men move like wild animals, out of poverty. The relationships derive out of poverty. And men run from one house to the other. People run off to Great Britain to do their own thing. Whole set of men left the place for the London transport. And a whole set of men, they move out for immigration into the United States of America. And prior to that, 40,000 plus into Panama. Mainly men. Mainly men. It's just a natural function that if all the men left the place, all the men left the place, everybody lived for about 8 square feet of land. They got about 6 houses, about 8 square feet of land. And one border is the other border, and the gate that you go through to go out is the gate that you go through to go in. That sometimes a man can shift from the backyard and go in another backyard. Or if the woman experiencing difficulties or the man experiencing difficulties, somebody, you know, people don't like me to talk these things, but I like to see the world as it is, because, sir, I would like to be able to say something that they might sound humorous sometimes, but I would like to say something to at least create a picture of our reality. So if you talk from the top of your head alone, and you don't think about what you see and what you know, then we would not be making laws that are relevant to the situation that we're in. If years ago, when people were calling people bastards, none of the leaders of Barbados, none of the people in this parliament did not consider it to be a severe social issue that damaged the psyche of our young men and women, or used to be mostly men that used to hear these things. If somebody felt that that was trivial and just dismissed it, you would be hearing that all over Barbados every day in almost every conversation, because it is mainly the working class people that seldom married. And the reality is that we are not as passionate about it as people who believe that in order to appear to be, tell me the best one. The people who come from the upper echelons of the society, the affluent type, they believe that in order to be seen as dignified, in order to feel that sense of prestige, that there's nothing wrong with buying a dress for $5,000 and buying the most expensive ring with diamonds and sign off on the contract and Christianizing the relationship. And the relationship becomes holy on the specific day where this thing occurs. Everything, all of a sudden, they pull up the thing over your head and everything now is Christianized. And they believe that the day after that, they must be respected. But the same two people that doing that came from a parentage that never shared in such a ritual, because they had to struggle and study survival every day. And sometimes the things that happen in your life, if you talk to women, the things that happen in their life during that struggle is because of poverty. Relationships, you talk to men, and you hear men saying, look, man, it was all right for me. I cared. I loved my 2 children. But then she had a sister, and the sister had 3, and the sister lived in the same house. The mother and the grandmother lived in the same house. I go to a certain country in the Caribbean, and 16 people live in a house. Every room in the house is a bedroom. Poverty. Poverty. I like to hear somebody say, my sister, and then the other sister said, my uncle, all these things happen. So I'm just saying that the law should reflect the personal experience of the people that the law is made for. And the people who are supposed to interpret the behavior of these people, the unions, and I talk about unions in a very wide sense. For me, a union is the definition that's given by the village, not the Family Law Act or even the Maintenance Act. The village defines family. The village defines union. And the culture of the people who attribute greater intelligence and what kind of institutions we must have, what they believe is a family, probably it is a family, but it's not the only exclusive family that exists. And we need to be able to wrestling with some of these challenges, these complexities, because of our own experiences, and see how we can put things in order so that all families of all different types, visiting relationships, everything can feel a sense of equality and a sense of dignity, regardless of what was responsible for their existence. I don't, sir, I respect, and I would continue to support the required amendments to the law, the Family Law Act, but I still believe that we need to go a little further. I think by admission, we're saying that the person who are supposed to be presiding over these contentious issues, they cannot make a clear judgment on them. So then they have to set it to a clerk who becomes sometimes not even qualified beyond CXCs. Sometimes they are. But you send it to a clerk, you send it to a man who calls himself a counselor, and some of these counselors are very smart counselors too. That is our reality. That sometimes the counselor counsels too long. And then he might even end up telling you, but you're in the hands of the wrong partner. And he then might try to become the partner. Because we have counselors that they have no specialty. Or even if they have a specialty in terms of certification, they don't have much practical experience, and here they are trying to resolve a problem, trying either to put a relationship together or suggesting that the relationship is best separate and distinct. But so an open discussion on, and I think the leader of the opposition was saying something about how we need to have a clear understanding of these family relationships. And that's why I say, sir, that at the level of the counselor, at the level of the judiciary, at the level of parliament, we have to face a number of realities. I don't believe that we're doing as good as we should, not at parliament, but sometimes the information needs to be fed back to us to say, look, these are issues that we must address. I am trying, and I believe most of us are trying, to find out what it is that constitutes sometimes the kind of tensions in the society in which we live. There are too many young people feel unwanted. And areas that we don't focus on, in my view, are contributing to the tensions in the society. I would say and say again, God did not curse us within the last 2 years. We are unable to identify what are the issues that are giving rise to certain tensions in this society every day. God didn't change his mind about black men and black women overnight. We have responsibilities. People might say it is as a consequence of poverty. I don't believe it's poverty alone, but poverty has made a major contribution. I believe as policy decision makers in here, we have to, rather than address these issues in any robot form, deep, profound thought must be applied to the challenges that we are facing in our society that is giving rise to the disintegration, the so-called dysfunctional family structures that exist in this society. And in my view, we have to also examine what constitutes dysfunctional. Because what you might call dysfunctional at the level of the worker class is the norm. It's the norm. And if the so-called dysfunctional behavior that you call it, did not exist from the first quarter of the 20th century, the population of Barbados, the black population, was about 23% or 24%. You know that's a premise that, that everybody will not agree with. But the reality is that is because of the relationships that derive after a small population, sometimes dropping below 200,000, and you have major migration to Panama, major migration to Costa Rica, major migration in the mid part of that century to England, and major migration to the United States. Remember the farm labor program, transport board nurses, whatever, Panama Canal. It is as a result of the active nature of our men and women in that 20th century that this black population was able to sustain itself and still continue numerically to dominate by being over 95% of this population. And there are people who would condemn that behavior in the first half of the 20th century, although the same behavior is responsible for their own existence. Now, what kind of rationale can you apply to a man who is thinking in that particular manner? I don't want to talk about anybody's personal experiences, but I know that. So I am saying that I understand the amendments. I fully support the amendments, but all I'm saying is that in the future, I believe that we need to have training courses for the judiciary, training courses for people who work in the welfare department. I need to see behavior that don't send specific social types to the welfare department for counseling. If you want to send people for counseling, I don't want to say I don't practical behavior. The judiciary should send married women and men to the welfare department too. I don't send poor people down to the welfare department, and everybody in here every day critical about how people in the department treats people, but then you send people from a court to these same people to talk to them about the challenges that they're facing in life. Well, this is madness that we're talking about. It can't work that way. So you always have tensions because one group of people believe that they are separate and distinct from another group, and that certain types of behavior must be attributed to a certain group. My girlfriend must go to the welfare department, must go to the welfare department if there's a breakdown in the family. But the accepted family now goes to the High Court. You don't turn up in the shirt jack. Minister, you don't turn up in the shirt jack. You got to go to the High Court looking right. So you have to dress right. And you're going in there for doing the same thing that the man for the working class community is doing. But you're treated in a completely different way. And the law, they have special provisions inside the Family Law Act that you apply because you're dealing with it is classism. You know, you got racism, that is classism in the law. And if we are trying to build, in my view, an egalitarian society, not only from the perspective of economic enfranchisement, we have to take all of these social disparities into consideration. And as a new parliament, we need to have some serious debates on these issues. Somebody must take them and make them refined. I can't refine them. I can only give you it in the raw form. But I know that there are a number of contradictions and there are a number of ironic areas of the law that we need to look at carefully. Sir, I want to thank you for allowing me to say at least a few words on this. Exclusively made for the lawyers, sir. Thank you very much.
Honourable member for Christchurch. So,
I'm obliged to you, Mr. Speaker. It pleases me to join the debate, and I feel obliged to do so since I belong to the legal profession. I tempt immodesty if I say that I am now into my 36th year of active practice at the bar. I neither expected nor invited that applause, but I'm grateful for it. And being so experienced in the law, let me say that I have been a witness to a revolution in the family law, and I will come to it shortly, but that revolution took place around 1982, and I will come to that shortly. I believe this legislation today concerns itself with matters of administration, how the family law is administered in relation to matters that have come before the courts. You are aware, Your Honor, that apart from matters of procedure, the law concerns itself with substantive matters. And you will permit me today, I hope, to concern myself with substantive matters as they pertain to the family law. And family law is interesting, and it touches a chord among us, that being what it is. It touches matters of personal esteem and social esteem among persons in this society, and I think it is always important legislation whenever it comes before the House. When I began the study of family law sometime back in the early 1980s, family law at that time began with a definition of marriage. It did not begin with property rights. It did not begin with the status of children. It did not begin with issues of who was the head of the household. Family law began, the study of family law began with a definition of marriage. It began at marriage, Your Honor. And you and I know what that definition was then, and except that it has now been liberalized by the Family Law Act of 1982, I believe that that is a definition that remains largely undisturbed today. It was Lord Justice Penzance in a case called Hyde and Hyde who said that marriage as understood in Christendom may be defined as the voluntary union for life of one man and one woman to the exclusion of all others. Inherent in that statement were many issues. The judge was saying that, well, of course, he began by saying he understands this to be the definition in Christendom, so that we are speaking here of Judeo-Christian standards and values, and that is where he located his definition of marriage. Of course, he said it was voluntary, and you smile, sir, because you and I know that unless the man and the woman exercise free will, that marriage may be annulled. The infamous shotgun marriage, therefore, is a nullity in law. Inherent within his definition, he said, and I hope this does not shock our people, but he said that it is a union for life. He was saying that it was permanent. And of course, I do not know how you could have that definition and make allowance for divorce. But that is the judge's definition when he issued his statement. He went on to say that it was a union between one man and one woman. In other words, it was heterosexual. And not only was it heterosexual, but being to the exclusion of all others, it was monogamous. And those definitions still apply within the law of Barbados. But that is not the fundamental point that I wish to make. The fundamental point that I wish to make today is that that definition of marriage, which we carried in this country up to 1982, modern Barbados, 1982 is most recent, that there was a dissonance between that definition of marriage and what we know to be the social reality in Barbados. I heard the Honourable Member, who I always enjoy listening to, the Honourable Member for St. Michael East, make reference to the seminal work of Edith Clarke. I don't know if you can apply seminal to a woman, but for want of a better term, let us describe that as her seminal work, in which she exposed the reality of the Caribbean family in the very title of her book when she says, "My mother who fathered me." And she was exposing the reality that in Caribbean society, and certainly in Barbados, that most families did not accord with the definition subscribed to, in the case Hyde and Hyde, an English case by an English judge, pronounced by an English judge long before, except that this society with its value systems applied that definition to the social reality in Barbados, or to the law in Barbados. But the social reality was that most families in Barbados, 68 to 70% of the families in Barbados, did not have the dignified definition of family. The law did not consider their arrangement to be within the definitions of family. So we have a conundrum. There's a dissonance between social reality and what the law says. No wonder Bumble says that quite often the law is an ass. Because here's the law going in one direction, and here are the people going in a different direction with their social reality. That 68 to 70% of the families in Barbados were headed by a woman. And the woman was sole head, and there was no man within that arrangement. And if there was a man, if there were such a man, he was absent or he was visiting. But most of the families in Barbados were matrifocal. And apart from being matrifocal, there was often the presence of a grandmother. There would have been the presence of a sister of the lady or a brother of the lady, housing being what it was at that time. The extended family had to be accommodated. And so that was a social reality colliding with what we were being told in our universities in this Caribbean. What we were being told was family. And what we were being told was family was not family, according to the social trends. Now, when one does research by computer, this Google phenomenon, there are some locations that will wish to say to you that the title of Edith Clarke's book, My Mother Who Fathered Me, is hers. She herself may admit to you that she drew inspiration from our own Professor George Lamin, who wrote that phraseology in his seminal work, In the Castle of My Skin. He spoke of the phenomenon of women heading households, of a mother who fathered an entire family. And as I said before, that was the reality in the Caribbean. Matrifocal and extended, a mother being present, and if there were a father, he was visiting or entirely absent, or indeed, in the most tragic of cases, a figment of the child's imagination, either through death or deliberate absenteeism from that unit we call family. What Lord Penzance was referring to is what we call in this region, and indeed in Europe, the nuclear family. A man, a woman, 2 children, a house and a dog. The nuclear family. A European conception that applied in Barbados only in 20% of the cases of the family unit in this country. I make the point again that there was a collision, there was a dissonance between the law and the social reality in this country. The wider point must be that the family law in this country needs to be amended and attended to constantly. It must always be updated. This society cannot find itself comfortable with an institution of law that is irrelevant, or an institution of law that is anathema to the development of the people of this country. And therefore, it is in that spirit that I always support amendments in the law when those amendments seek to embrace the social reality, and when that social reality is in itself not undignified, and indeed when it is progressive, because there is nothing, let the word go forth, that there has been nothing undignified about the matrifocal or extended family that has existed in this country from the time of settlement. Let that word go forth. When we were schoolboys, some of us, the children of married parents, some of us, the children headed by families in which a mother was dominant. We were clothed no less, we were housed no less, we were fed no less, and we certainly were not loved any less. So that the word must go forth, that the law must always seek, the family law must always seek to accord dignity to those whom we have felt in the past were an undignified lot. And that is why I come to 1982. No debate on family law in this country will ever be complete unless we refer to the revolutionary legislation passed. And I don't like to be partisan unnecessarily. This is a parliament, and sometimes we shed the clothes of partisanship, but I want to pause and to congratulate Sir Henry Ford for passing legislation which has been revolutionary, the 1982 Family Law Act. And I will not mention the name Sir Henry Ford unless I also mention the name of Appeal Justice, now retired, Errol Chase. And it is Justice Chase, who I understand was responsible for the term, coining the term, union other than a marriage. So that Family Law Act gave equal dignity to married persons as it did to unmarried persons. And they were described as unions other than a marriage. And you know the prescription, you know how it went. That if a man and a woman cohabited continuously for a period of 5 years, the law, the Family Law Act of 1982, treated them equally as it did persons who had gone before a priest or indeed a bishop and had their nuptials formalized. And that was revolutionary. I heard the Honourable Member for St. Michael East use the word dignity. That law gave equal dignity, social dignity, to all families in Barbados who were without the protective cloak of legal dignity. We often speak of the Family Law Act of 1982, and sometimes we forget to mention the Status of Children's Act. You know the term, and I don't like to use it, but sometimes we have to embrace even the unpleasant aspects of our lives. The member for St. Michael East spoke of bastardy. Most unhappy word. But you and I grew up in a society, sir, in the 60s and 70s, and that term was not used with any affection. And it was used disaffectionately because the law also disadvantaged young boys who were born out of wedlock and young girls who were born out of wedlock. And having a child indeed out of wedlock was a badge of shame. What was the law doing in relation to this social reality? The law was ill-treating that social reality. And that is why I say today, that law has been revolutionary, and it must be acknowledged. And whenever there's a debate on family law, this country must pause and recognize what this parliament has done, what a past parliament did in 1982 in bringing into equal dignity extended matrifocal families under the protective umbrella of the family law in this country. So that when we speak of family, we also speak of property rights. Property rights. The 1982 Family Law Act, and I know a lot of people get very sensitive and discomforted when we speak of property rights within the context of marriage. But you know, Your Honor, previously and prior to 1982 and prior to 1975 and into the 50s and 40s, women hardly had any rights in this country in relation to property, married or unmarried. I heard the Honourable Member for St. Thomas say this morning that even married women had to endure abuse within the union of marriage. They had to endure it, Your Honor, because there was literally and physically nowhere to go. There was no escape. And she told me during the break of a case in which the grandmother, I beg your pardon, the mother of the married woman would say to the married woman who is a victim of abuse, "You're not coming back here, stay with your husband. Stay and be a wife." And that is what the revolutionary law of 1982 alleviated women in Barbados from. And in the minority of cases where men suffer abuse, the minority of cases where men suffer abuse, the law, the development of the family law has served to alleviate victims of spousal and domestic abuse, that they can go before the courts and find some measure of relief. I spoke of property, Your Honor. Is this society aware that prior to these developments in the law, I'll pause and mention the Succession Act of 1975. In the event that I'm accused of being partisan, this is no occasion for partisanship. This is for sterile partisanship. This is an occasion for truth, and let truth be told. That the Succession Act of 1975 was also a revolutionary piece of legislation in that it enfranchised thousands of people in this country, that if a man had 5 daughters prior to all this legislation, and then he had a son on the 6th occasion of pregnancy, that son inherited in superiority to the 5 daughters, and that it was always the first son, and that several children in this country were at the mercy of a dying man hoping that he would write a will to include them. Because almost naturally, his property went to the children of his wife and to his wife. But the Status of Children Act and the Succession Act would have dealt with that. All children born of a woman became equal in this country. Is not the law then a good thing? At some times. And I repeat, Your Honor, that the law became a good thing. In 1981, with the passage of the Status of Children Act, in 1975, with the passage of the Succession Act, and in 1982, with the passage of the Family Law Act. And if this legislation today, procedural as it is, sits within that tradition of progressive liberalism when it comes to changing, to amending the law, then if it is in that tradition, Your Honor, it is well done. And being well done, Your Honor, it is my pleasure to support it. I'm obliged to you, sir.
Honourable Member for St. Michael Southeast.
East.
Southeast.
Thank you. Thank you, Mr. Speaker. I too rise to support the amendments to the current legislation. Honourable members who have spoken before have sought to provide not just a historical context to the amendments, but also sought to address a number of issues that I believe are plaguing our society presently in relation to the role of the family, and certainly in relation to the whole issue of divorce as is taking place across the country. Sir, I would have had the opportunity while in practice to work in the family law courts. In the civil area such as family law, I must tell you that I try to stay away as much as possible from the contentious divorce matters, particularly when they involve children, because I've always felt that when people come together, they come together and do so, and there are two people engaging in all of the niceties that are involved in relationships. But then when they have to part ways, a judge, or in some cases a magistrate, is then asked along with the attorneys to make certain determinations as it relates to not just property, but also as it relates to, regrettably, sometimes how children are also dealt with. In the time that I've practiced in the civil court, sir, while I applaud the efforts made by this Attorney General to ensure that this process is obviously sped up, I must say that I have had some concerns over the years in relation to the handling of children, in particular as a result of divorce, and the consequences that come as a result of divorce. Oftentimes, the orders of the court, apart from granting the Section 27 and 42 orders, would often, particularly where there are children involved, speak to a scenario of children having to go to a parent on alternate weekends for access. In some cases, the parent who has the custody of the child on a day-to-day basis, sir, while the parties may have joint custody, the person who has the day-to-day care and control of that child oftentimes has used the custody right for the care and control to basically control the other party as well. And that has often led to our young children in this society having sometimes to be back and forth between parents. It has, as a result, especially if the persons are not getting along, which often is the case where after a divorce, persons are not getting along well. I have seen the strain that it has put on, in particular, young people in families being shuffled from one household to the other. In many instances, sir, even the difficulty of being able to have the hours regulated for children as well becomes a problem. The court order would often say you have to get the child back by 6 p.m. on the evening of the Friday, and then you have them until the morning of the Monday, and you have to take them to school. And while it seems from the perspective of the court oftentimes that we were doing the best thing, having now had the opportunity to be a constituency representative, sir, I must say to this chamber that I'm also seeing another dynamic playing out where children are very torn as a result of those same orders that we believe sometimes were meant to structure their family life. In many instances, the children that I interact with are very concerned about not being able to have that stability that a lot of children often enjoy. I think many of us, it would be fair to say, in this chamber have had at one point some level of stability, whether in relation to two parents in a household or even the extended family. But regrettably, what we are seeing across the system and across our society today, sir, is a very worrying circumstance where many children do not have that stability. I encounter children, sir, who are concerned about their parents' financial circumstances. You know, they're being asked to perform well in school, but apart from being shuffled from one house to the next, they're also having to deal with issues of unemployment. Sometimes the light is off, so the school children are unable to get their school uniforms ironed in time for school. Sir, there are concerns about whether the water sometimes may be off. And the burden that is being placed on this generation, sir, is a very difficult one, and which I believe is now manifesting itself in a way that we are now seeing so much violence and so much anger being acted out by our students, certainly across the educational system, but also across wider society. I don't often agree with the Honourable Leader of the Opposition, Member for St. Michael West, but in his contribution, he spoke about family and the breakdown of family and really calling us to look at and reflect on what is really transpiring. And I think a lot of the social and economic issues are really impacting on the family environment as we once knew it. Lots of the parents nowadays are younger. They themselves do not have the coping skills or the coping mechanisms to deal with the responsibility of parenting. I had the opportunity this weekend to, while I was in the constituency at an Independence Fund Day, to part a little skirmish between some young ladies. They're all in primary school. And in discussing with them their concerns, many of them, they didn't speak about divorce specifically, but they spoke, as the member for St. Michael East referenced just now, about the absence of particular parents in the household. They spoke about parents not having enough time with them. They spoke about a range of issues, the bullying, feeling as though they were not part of society. They were very distressed, sir, and lots of what they spoke about connected back to the whole issue of family and the support systems, or the lack of support systems that many of our young people are encountering today. When I speak often of getting back to our basics, I speak of it, sir, because there was a time when communities and people in communities looked out for children. What we're experiencing now is not new. People always had to struggle in one way or the other. We are fortunate we don't have as many pit toilets as we once had in another generation, but we still have them. But a lot of the things that, and the advances that have been made, many of the young people in this generation are still being confronted with certain difficulties, sir. And I think that is what we are seeing across society, impacting us in a major way and creating significant difficulties for us, because many of them are angry. They're angry at parents, they're angry at the communities and the people within the communities for not looking out for them. They're angry because sometimes they don't have activities to be able to engage them. They're angry because the court makes a decision that they are supposed to spend time with a parent that may not have spent a lot of time with them. And they're angry because sometimes the parent may not be working to provide the financial support, and when they live in a household where sometimes they have siblings from other parents and those individuals are able to provide for those children, they're angry because they're not getting what they believe they should be entitled to as well. So when we speak of separation or we speak of divorce, I agree with the Honourable Member for St. Michael East that we have to look at the wider issue of the traditional form of divorce. We have a lot of separation taking place in families across this country. The visiting relationship, as he spoke about, is a prime example. Persons in some cases are married and they engage in unions with other persons, and then they are not able to provide the stability on an ongoing basis for the children that they have brought into this world. That is creating a problem as well for our young people across this country, because I'm sure that while many people have been products of those types of relationships, the reality is that this generation is dealing with it differently. And this generation is acting out in a different way to previous generations because of all of the other things that they're also having to grapple with in their lives. So the last administration didn't seem to focus a lot on the whole issue of parental education and strengthening parental education. But I too believe that while we speak about all other kinds of education, we also have to address this issue of parenting. I know the last Barbados Labour Party administration spent a lot of resources ensuring that entities like Barbados were strengthened to be able to provide support. As a practicing lawyer, I recall there were many orders too made for parents to attend Barbados. And in many cases, parents tended not to attend on some occasions. Sometimes they did, but because of work commitments, you would often find that one parent may not be able to attend. And as a consequence, while in some cases it may have helped some families because of the issues of employment and the inability to be released from employment, I think we didn't have the full benefit of it. I'm a firm believer that a number of these services need to be decentralized, that instead of having a central point where sometimes parents are able to participate in these sessions to learn about parenting and to be able to cope, that perhaps we need to utilize our community centers in a different way. It isn't just for community activities alone or for persons who want to have events, but I think that our community centers also need to be points where the entities like Barbados and other NGOs can certainly play a part in organizing events that would engage parents to help them to cope. Many times the parents are struggling too because they don't know sometimes what challenges their children have, and they don't know how to cope with the challenges that children have. And as a consequence, you find that one parent is blaming the other parent because the child may be dyslexic or the child may be autistic in some way. Those are things that parenting sessions, I believe, if we have them deployed across communities and across our constituencies, can certainly help to inform and to educate parents as to how to cope. A child that presents with a learning deficit is oftentimes in certain households, sometimes the parents start to blame each other and to attribute the challenge to a particular parent. And I think, sir, we have to really look carefully at this area of parental education, because no matter how we want to run from it or how we don't want to accept it, we have a lot of young people in our society who really do not understand what it means to be a good parent. I have had the fortune of having a father who not just idolizes me, but who has been there with me through thick and thin, and also a mother as well. I came from an extended family of a grandparent who also raised me. I understand, while I don't have children, I understand what it means to have persons in your life who care about you. And I think that we have to get back to the basics of being able, those who have had the benefit of such need to try more to be able to encourage persons when you see that they're going astray or they're not being what we consider to be a good parent, to be able to mentor and to provide that insight to show them that they need to pay more attention to their children. It means, sir, that as we even look at the whole issue of education reform, that the whole aspect of teaching responsibility has to start within the school. It can no longer be that we wait until people have children and then we are rushing to try to give them information as to how to cope and how to manage and to deal with all of these issues. It means that we have to start to introduce children, not to encourage them to have children, but we have to empower them with the information to understand what it means to be an adult. I think that we have missed the boat in terms of being able to not just equip our young people with an understanding of the responsibilities of adulthood. And that doesn't mean just getting a driver's license. It doesn't just mean having the right to vote, sir. It also means if you determine that you are going to be engaged in sexual activity, there is a likelihood, if you are having unprotected sex, that you may bring a child into this world, and therefore you now have responsibility for that child. And sir, I am one that calls it as I see it, because I believe that we have to speak the language of our young people, and we have to speak to parents in a way that they understand as well. It is not anymore about being the friend of a child, but making sure that you can provide a certain level of mentorship and leadership for the young people that you bring into this society. So I support the efforts to introduce more parental education, whether at the level of when persons are being engaged in divorce matters, or whether it is at the level of community intervention and also at the level of the schools, because I see that this is a common trend across our society where parents simply say to you, "Ma'am, I cannot cope, I don't know what to do with this child. The child has become disrespectful because me and the father have separated, and the child is acting out as a consequence of X, Y, and Z." Whether it is divorce, whether it is separation, we have to hit this issue head on and be able to arm our parents and also our young people with the information to be able to allow them, sir, to cope. So I'm happy that this amendment is being made to the legislation. Anything that is going to make the family law courts move a lot faster and certainly make them more efficient is pleasing to my ears. I know that it is not a place that many people like to go, particularly in the magistrate's court, and that distinction has also been made by the member for St. Michael East. There is a huge difference in the treatment and the approach in the magistrate's court to particularly the maintenance matters than in the High Court. And it is something that I'm glad to hear as well the Honourable Attorney General has spoken to in terms of being able to get information to persons, via the phone, to allow them to know when maintenance is available. I think it is very unfortunate that something as simple as that new step is so long in coming, but it speaks volumes, I believe, sir, to sometimes the way we look down on people in our society, and I would hope that over the next few months that the steps are taken to be able to ensure that mothers and indeed fathers, as the case may be, do not have to go down to the court, to an office, to try to determine whether or not money has been left on an account for them. Again, we have to recognize that when a frustrated mother goes to the court and comes back home, and she has no money because the father was not working and he couldn't put the money there, that oftentimes parents don't keep it to themselves. They start to call the fathers all kinds of names. And a child is a representation of both parents. So if you keep hearing that your father is this and your mother is that, eventually you start to believe that you are at least 50% of whatever it is that you're constantly hearing. And therefore, as a government, we have to ensure that we also take the steps to make these things easier for people. Because one, if we create employment, fathers and mothers are able to provide for their children. And if we make the process less humiliating for people who have to go before the courts, we are also doing what we have been put here to do, to ensure that people do not feel humiliated in the process of being able to ensure that money is put aside for the maintenance of their children, sir. That is what we were put here to do. Because I recall the last administration, I believe it was the Honourable Prime Minister, making a pronouncement about making reforms to legislation to make it easier for women, in particular, to be able to go to the court to get their money. He told the country that money was put there and that you saw women in particular, and I say women in particular because women went down to the courts expecting that money that had not come for some time from their child fathers, that money was actually at the court waiting for them. And they were disappointed, sir. And again, you know, there are some things that we must never repeat in the history of this country, and certainly as this government. And it is promising people things that you then do not deliver on. I think the steps being taken by the AG is a step in the right direction, because if the money is there, and it is there by the father or the mother who is supposed to put it there, and a notification can come, that avoids the humiliation that many men and women have had to face going to the courts. Nobody needs to know that the father or the mother is not paying or supporting. And the other thing, sir, is that even when a parent is unable to support financially, I remember as an attorney, I would always say to the parties, make sure that you spend time with your children. Sometimes we forget that children are children, and children just like to know love and to feel love. And it doesn't have to come in the form of, you know, material things. We believe that as a society. But many children just want the pat on the shoulder. They just want those memories to be created with their parent. And particularly when parents have gone through a divorce more than ever, or any kind of separation, parents just need to know that their parents are there. Children just need to know their parents are there to support and to love them, sir. And therefore, I think that this amendment, as I said before, is a step in the right direction. I would want to commend the Honourable Attorney General for the efforts in bringing the amendments, and for all of the steps that are being taken to reform the judicial system and to make it easier for the persons who have to access these services on a daily basis. With those few words, sir, I'm obliged.
Member for St. Joseph.
Mr. Speaker, I did say that I would not keep members long. I gave no assurance, though, that other members in the chamber would not run afoul of my own personal indication. I don't think I need to say very much by way of wrap up. Let me thank colleagues for weighing in on this issue. Many of us are uncomfortable discussing the softer side of our lives and of our communities, but we can't run away from the difficulties that present themselves in the context of families and how the law deals with those families and tries to resolve the issues. I already gave the assurance early in the debate that this was a built-in agenda. In other words, we will not be stopping at making these kinds of changes or establishing the family law court. There will be many more elements that need to be implemented over the next few months. As we go into the estimates process, some of these elements will be given the required financing so that early in the next financial year we would see even more initiatives being rolled out. I'd like to say that, you know, sir, the last administration talked a lot and did very little. I well remember in this chamber the former Attorney General saying, we have agreed to increase the number of judges. But when I looked at the files that I saw when I became Attorney General, nowhere was there any indication that that would happen. Nowhere was there any arrangements made for their physical accommodation, nothing of the sort. But we are an administration that seeks to deliver to the people the things that are required as they go about their daily lives. Mr. Speaker, I commend these amendments to you, and as we look to make more changes, I look forward to the support of the opposition, of yourself, Mr. Speaker, and of the members of this chamber as we try to completely transform the delivery of justice for every single Barbadian and also in every area of our existence. Mr. Speaker, I therefore beg to move that this bill be read a second time.
Honourable, we have to specify. Honourable member. To specify.
Order number 6, sir. That is
Right.
the
Family law,
family
dissolution of
law
marriage,
miscellaneous provisions.
Yes, that one.
Yes. Beg to move that the family law miscellaneous provisions bill be read a second time.
The question is that the aforementioned bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Elect him. You have to elect.
Mr. Speaker, I beg to move that the honourable member for Christchurch South be appointed the chairman of committees.
The question is that the honourable member for Christchurch South be appointed chairman of committees for the duration of this sitting. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it. The honourable member for Christchurch South is so appointed. No. You got to beg to move.
Now leave the chair and the House resolve itself into committee for further consideration of this bill.
The question is that the honourable speaker do leave the chair and the chairman, the honourable member for Christchurch South. No, Christchurch South. Right. That the House resolve itself into committee for further consideration of this bill. Please say aye. Those against, please say no. Me think the ayes have it.
This House is now in committee.
Beg to move that clause 1 stand part.
Question is that clause 1 now stand part. All those members in favor, please affirm. All those against, please say no.
Affirmed.
Honourable member for St. Joseph, I think this House is due something of an explanation from me as to the use of language. We've been in here for some time, and I've heard several speeches on that deal with cultural affirmation and decolonization. And I feel that if we are in a house, in a sovereign country, in a sovereign parliament, I think the time, and this is certainly speaking for me, as long as I'm here, I am going to be using the language that reflects cultural repatriations. And therefore, hold on, Honourable Member St. Michael West. Therefore, I am taking this very seriously. This is the language I intend to use on every occasion that I'm asked to occupy this seat. And I will use the language that is familiar to this country. The language that we're being asked to use is archaic.
Anachronistic.
It is a dialect of England in the Middle Ages. And if the House feels that it wishes to use that language, it can. But this is a personal decision I've taken, and therefore, those who wish to subscribe to it may do so, and those who do not wish to subscribe to it may also do so. Proceed, Member for St. Joseph. In response to the Honourable Member for St. Michael West, unless I hear a negative, I will, the Honourable Member can call for division. But unless I hear a no, I will assume that it is unanimous. You can call for a division if you wish to, but I will always assume that it is unanimous when I do not hear no. And I'm very serious about that.
Or number. Beg to move that clause. May it please you, Mr. Acting Chairman.
Yes.
I hereby move that Clause 2 remains a part of the bill.
Thank you very much. Question is that Clause 2 remains...
I wish to second that.
Just a second, Honourable Member. The question is that Clause 2 remains part of the bill? Any seconders?
I wish to second that.
So seconded.
All
All those in favor, please say yes. All those against, please say no. It appears as if the affirmations are unanimous.
I ask Mr. Acting Chairman that the schedule be the schedule to the aforesaid bill,
Question is
which I
that,
now look upon.
question is that the schedule be the schedule to the aforementioned bill. All those in favor, please say yes. And all those against, please say no. It appears as if the affirmations are unanimous. Is that it, Honourable Member?
I ask, sir, that you now report to His Honour, the Speaker, the passing of one bill in committee.
Question is that I now report to the Honourable Speaker.
The passing of one bill in
The passing of one bill, I'm obliged to you. All those in favor, please say yes. All those against, please say no. It appears as if the affirmations are once again unanimous. I'm obliged to you, Honourable Member. There he is.
The chair of the committee is reporting the passing of one bill in committee.
to move that this bill be read a third time.
The question is that this bill be read a third time. All those honourable members in favor, please say aye.
Aye.
Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be set as the Family Law Miscellaneous Provisions Act 2019.
The question is that the aforementioned bill be not passed and so cited. All those honourable members in favor, please say aye.
Aye.
Those against, please say no. Me think the ayes have it. This bill is passed and so cited.
Order number 5, in the name of the Honourable Attorney General, to move the second reading of the family law, dissolution of marriage, validation and indemnification bill 2019.
Mr. Speaker, I beg to move that this bill be read a second time.
Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg that you do not leave the chair and that this House resolve itself into committee for further consideration of the bill.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favor, please say aye. Aye. Yes. Those against, please say no. Me think the ayes have it.
This House is now in committee.
There's some traditions. Beg to move that clause 1 stand part.
Beg second.
Question is that clause 1 stand part. All members in favor, please say yes. All against, say no. It appears as if the affirmations are unanimous.
Beg to move that clause 2 stand part.
Beg to second.
Question is that clause 2 now stand part. All those in favor, please say yes. All those against, please say no. Yes, Honor. Beg your pardon?
Mr. Acting Chairman, I beg that you do not report to His Honour the Speaker the passing of one bill in committee.
Beg your pardon? Member for St. Joseph, do you mind doing it again, please? I think the member for St. Michael West's question. Let's just do it again. It will take a few seconds.
Questioning what?
Let him speak.
Mr. Speaker, I was just saying that the result of the vote was not announced. That's all I was saying.
Just do the second one again, please. Thank you.
Beg to move that clause 2 stand part.
Question is that clause 2 now stand part. All those in favor, please say yes. All those against, please say no.
Beg to move that you do not leave the chair and that this hope and that you
It appears as if
report to His
the-
Honor the Speaker the passing
Yeah,
of one bill in committee.
I think he wants the result announced, and it appears as if the affirmations are unanimous, so there we are.
There was no division? There was no division?
Yeah, but he wants it announced, so I've announced it.
Mr. Acting Chairman, with respect, you've called the vote. The vote has been taken, and you rule on the vote.
Yes, I have.
You have
I
ruled on the vote.
I have,
know
yes.
what. I haven't ruled on the vote. I don't understand what the issue is. Your ruling of the vote
Yes,
is
I've ruled, I've
is not
ruled.
justiciable?
Mr. Chairman, with all due respect, all I was saying is the vote was taken. You did not rule on the vote. You did not in the first instance.
And I have now so ruled.
You have no so rule.
Thank you very much.
Thank you. That's all I was saying.
Thank you, thank you. Speaker.
The chairman of committees has reported the passing of one bill in committee.
Beg to move that this bill be read a third time.
Beg to second.
The question is that the aforementioned bill be read a third time. All those honorable members in favor, please say aye.
Aye.
Those ag-
Mr. Speaker, I beg to move that this bill do now pass and be cited the Family Law, Dissolution of Marriages, Validation and Indemnification Act 2019.
Beg to second.
The question is that the aforementioned bill be passed and so cited. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. This bill is passed and so cited.
Order number 4, sir. Order number 4, the name of the Honorable Attorney General and Minister of Legal Affairs to move the second reading of the offenses against the person of 19.
Honorable member for St. Joseph.
Mr. Speaker, this is a small but important matter. Last year, this chamber made amendments to the Offenses Against the Person Act so as to give full effect to the decision in Severin and Nerve against the Crown. That was, or at that time, that was our most recent death penalty case. In fact, it is our most recent death penalty case. And that case, by virtue of determining, this is the CCJ decision, by virtue of determining that all sentences of death carried out under the law as it then stood were unconstitutional, it meant, therefore, sir, that none of the death penalties which had been pronounced by our criminal court could stand. That then triggered a need for resentencing, because if the penalty that you have imposed is not sustainable in law, then you have to go back to the penalty phase and and reconsider the matter and determine what sentence you would impose on that person convicted of murder. The arrangements that we put in place at the time seemed workable, and it was a simple one, and it is that the Chief Justice would review the matter and make a determination of the sentence that would be imposed. But, sir, that has proven to be impractical for some very simple reasons. Murder cases are long and complex, generally, and the Chief Justice would not have heard the case at first instance. So he would have had to go through the relatively sterile exercise of reading the record, reading the testimony of witnesses and so on, and then trying to determine for himself what sentence would be appropriate in the instant case. It is easier said than done. There's a lot to be gained, Mr. Speaker, by looking at the demeanor of the accused as he speaks, by looking at the demeanor of the witnesses, all of those kinds of things. And the Chief Justice would not have had the benefit of any of that experience on a live basis during the trial. No resentences have been done, but it continues to be an injustice to the individuals who had been convicted of murder and given the death penalty, for them to remain in a state of limbo, because while the death penalty could no longer be imposed, there would be an obvious lacuna in that they would not know what it is that they're now sentenced to serve. In fact, sir, it is possible that an individual might still be in prison, but a sentence that would now be reimposed might have expired. And therefore, it is important for us to ensure that these sentences that the resentencing is done with all possible dispatch. And the right thing to do would be for the judge, so long as that judge remains available to do it, to do the resentencing. In a situation where that judge is no longer able to do the resentencing, perhaps because they've left the bench, then the Chief Justice would do it. And that is possible. So we've had a few people who've left the High Court, not in real recent years, but we have had some people who have left the High Court, and people will continue to leave the High Court, sir. So it is certainly the better position that the judge who did the trial would be the person who is at first asked to do the resentencing. If that person is no longer on the bench, then the Chief Justice, whoever he or she may be, at any given time would do the resentencing. But the preference would be for the judge who heard the witnesses, who was there to see how the case unfolded and so on, to make the decision as to what sentence would be appropriate. Mr. Speaker, so far since September, I think we've had about 7 murder trials, and I can assure the Chamber that priority is being given by the DPP and by the High Court to make sure that murder trials are done with all possible dispatch. I told the Chamber since last year that we'd had a large number of homicides, a large number of murder accused who were awaiting trial. I'd given figures at that time of in the region of almost 70. And of course that number has gone up, not by too much, but it's still gone up since then. And the DPP's office has very kindly agreed to give murder trials a priority. But while giving murder trials de novo, new murder trials a priority, sir, we still have to make sure that we do right by the accused, by those convicted persons who are still in prison, who have no idea whether they're going to be in prison for the rest of their life, whether they will now be sentenced to death, or whether they will be, well, not sentenced to death, they couldn't be, but whether they would be given a few more years or less. So that is an unsatisfactory situation, and this bill seeks to remedy that, sir. The sooner we can get this arrangement put in place, the sooner we'll see the resentencing done and try to bring some normalcy back to the judicial system and our system of penalties. With those few words, I beg to move that this bill be read a second time.
Honourable Member for St. Peter.
Thank you very much, Mr. Speaker. I will, like the Honourable Attorney General, be pretty brief, but I thought that I needed to just say a few words on the bill which seeks to do what is legally necessary to ensure that the rule of law remains in effect in our country. And so that insofar as we've changed some of our laws to reflect the current thinking of the Caribbean Court of Justice and other international treaties and understanding of law, I thought it appropriate that the situation that gives rise to this matter, that is to say, the acts that would have occasioned persons appearing in court in the first place, charged with capital offenses, and having to go through a trial and then be sentenced, and in this case, as this bill indicates, resentenced because of the developments, I thought it necessary to speak to the chamber of trying to get our minds to the point where we focus on not having our young people get to this stage. The intention of a country is not to penalize those who have committed wrong, but to try to create a society, sometimes we use the term a just society, but to create a society where people do much more right than wrong, where the wrong is limited. And wrong we refer to often as crime. Myself and the Honourable Member for St. Michael West might refer to sin. But it is doing stuff that is not right. And, as a youngster, my father did not believe in television. And he did not believe in it because of the negatives that he saw that it brought to homes, families, communities, societies. I often wondered how Cain ended up killing Abel without TV and North American influence. Maybe if I were a youngster now, I would be wondering how that happened without the internet, without any precedent for it taking place. And I think we have to accept what I consider to be the fact that there is a tendency in human beings to do wrong. And so there will, wherever there is a society, as a matter of fact, I believe that's part of the definition of a society, a construct that attempts to maintain good order among a group of people. And that is the reason why we have laws. But crime and criminal activity has been the scourge of societies throughout time. Sometimes I hear people talk about how violent some of our young people are, and I will not speak today for these few minutes. I will not try to compare responses of young people across generations. I will say, though, Mr. Speaker, that I believe that people, they have always been very cruel people, and they've always been decent people. I've read in scripture where the Bible talks about people who their thoughts and intents were evil continually. And I begin to wonder what kind of human being would be like that. I believe, yes, I do believe, according to the Honourable Member for St. Michael South, schooled as he is in some scripture, talks about the heart of man being deceitfully wicked, evil above all things and deceitfully wicked. But I believe that people respond with the tools that they have. And that is not just in terms of good people. But if the tool you have is a big rock, then you will hit a fellow with a big rock. If you have a knife, you may use the knife. If you have a gun, you may use the gun. And so I see no good reason to classify young people now, in spite of the violence that we are seeing, which is untenable, but I see no good reason in attempting to classify them as being worse than young people in any preceding generation. I think that is an approach and an argument that really has no merit, but I also think that it takes our view and our focus away from the real issues. If we spend all of our time talking about how cruel it is to chop up or to shoot, then we have less time and less intellectual energy to put into assessing the root causes of what we face and addressing our minds to looking toward solutions. And I think as a society, we ought to be looking towards solutions, but particularly as persons elected to lead and to represent people in a society, we have the responsibility of addressing our minds to root causes and solutions, as opposed to comparing and contrasting and attempting to suggest that in the modern era there is something worse than in eras past. I believe that it is easier to do wrong than to do right. I also think that as we address our minds toward what can we do, what can I do to help to address the situation so that we do not get to the point where we have to be looking at those who have committed capital crimes. We don't want to get there. I believe that adults, generally, leaders in particular, have, lawyers call it a duty of care in a slightly different context, but I believe that we have a responsibility to care for the young people in our society. I believe that adults have a responsibility to be nurturers of young people in our society. Children, babies, toddlers, young people have a need, a desire to be loved. And one of the things that is lacking in our society is that expression from adults to young people of the understanding that I care for you. It comes, Mr. Speaker, in my view, from a recognition that adults are in a position of responsibility. We are also in a position where we exert a lot more influence. And so we are not operating at the same power relation level. Young people are vulnerable. Young people have certain weaknesses. They can't do a lot of physically what adults can do intellectually. They need to be nurtured and they need to be cared for. And that, Mr. Speaker, goes, and one of my colleagues would have mentioned this in an earlier debate. I think it was the Honourable Member for St. Michael Southeast. Young people, especially at the early childhood, teenage years, need adults, not just parents, but need adults to invest time in their development. Need adults to invest of themselves, to demonstrate to young people that we are interested in seeing them grow, in seeing them mature, in seeing them do well for themselves at some point in time. Many times, and we are now, I believe, fully into the Christmas season, and too often, this is my view, adults, including parents, will use this opportunity to demonstrate a care for children by providing them with lots of material things. Often, material things are provided to people who have no need for material things, but just to demonstrate something. young people who need care and attention are given trinkets. And we spoke earlier about decolonization. But sometimes what we do with our young people, especially our children, is in my mind akin to what Columbus and those other rogues would have done to the indigenous people on this side of the Atlantic, presenting them with trinkets to make them happy for a time. We have to move past doing that with our young people. We have to move past just the gift given as a demonstration. The giving of material things without a demonstration of care which is manifested in time and dialogue, discussion, conversation, guidance, is in my view wasted. A waste of money, a waste of the trinkets that we sometimes give to our children. I also feel, Mr. Speaker, that adults have the role and must assume the role, must take back the role of mentor. I began by talking about Cain and Abel. I do not believe that Cain acted because he saw some bad action prior. I don't believe that. But I do feel very strongly today that young people often mimic what they see in adults. Adults have a responsibility to mimic that which is good. Now, we have a saying, and I believe that the honourable member for St. Michael West, I feel a little bit funny because I have no tending to agree with him. This is twice in one speech. Getting a little bit uncomfortable. But you know, sometimes in church we have a saying. We tell our people after they leave a worship service to have food for lunch rather than have the preacher for lunch. Because sometimes if you are not happy with a sermon, it is said, I don't know because I never saw it in my household, but it is said that people would go home and at the lunch table would choke the preacher, criticize, chew up the preacher, criticize, and those were things that happened in the presence of the entire family. So children grow up hearing that kind of response, even in a situation that one would think would be much more understanding and encouraging of the good, rather than those displays of what I consider bad behavior by adults. Adults need to remember, we all need to remember as adults, that our young people are watching us. And so some of the actions, some of the attitudes that we see in our young people are the acting out of attitudes that they've gotten from some of us adults. They may act them out in different ways, but some of them have at their base, have at their root, similar attitudes to the attitudes demonstrated by some adults. We talk a lot about productivity, working hard. Mr. Speaker, it has always amazed me that older people would say to you when you tell them, okay, I have now to go to work. They will tell you, okay, but don't work too hard. People who toil hard in the sun and in the rain to build Barbados at low wages would say to succeeding generations, don't work too hard. Now, I don't like generally to be critical, and maybe they speak out of a certain degree of ignorance, one, but also they may mean something that they're not actually saying. they may be speaking to do not be exploited. But when you say to a youngster, don't work too hard, do not turn around 20 years later and talk about lazy young people. Because you told them, don't work too hard. You give them the impression that by going to work for somebody, they're going to be exploiting you, so do just enough to keep your job. We as adults, Mr. Speaker, have to recognize that our young people are looking at us. They're soaking up those characteristics that we are demonstrating either by our words, by our actions, and sometimes just by our body language. They are soaking them up, and then they are reflecting them in their own actions. We as adults have to remember that we are role models. There's a verse in Scripture that I like. I think I understood it more after getting children. And it was David talking to the children of Israel, and he essentially said, raising children is a full-time job. If I were to distill the verse in Deuteronomy, that's what he was saying. Raising children is a full-time, it doesn't stop. Not full-time being 8 hours or 12 hours, because he said, you got to teach your children when you're walking, when you're standing up, when you're laying down, when you get up. You are always teaching, because it has been recognized for millennia that the inculcation of good values in children is both important and time-consuming. And so I agree with all those who suggest that, including the Honourable Member for St. Michael's Southeast, that some thought has to be given. I don't have the answer, but some thought has to be given on preparing people for parenthood. Some thought has to be given on preparing people for parenthood. We have to recognize that we are preparing our young people to become adults. And I heard the Honourable Member for St. Michael, South Central, speak sometime to the matter of adults having the responsibility of raising children to become adults, but indicating to the children that you can't have two adults in the same house. A contradiction in thinking, in thought, a conundrum that you place a child in, because you want a child to demonstrate maturity. You want a child in late teens to demonstrate that they have a grasp of how to reason and take care of themselves. But then you say to that child, if I tell you something, don't answer, because I am the man in the house, or I am the woman in the house. But we want our children to become responsible adults, as though the minute they leave under your roof, something will happen and they will become responsible adults, demonstrating that responsibility. We have to get to the point where we understand that, as Scripture says, children are an heritage of the Lord. We have a responsibility to take them from conception through to adulthood, because they're not really ours. We give birth and we assist in the Honourable Member for St. Thomas is smiling. She wanted to give me a word to use.
No, because you said we.
Because I said we?
Yes, she's
okay.
we.
Okay. Yeah, but we are participants.
But just so that
We are participants. Active. Well, Mr. Speaker, I hope that we are active participants, because I do not think we were created to be passive participants. I serve a God who wants us to be happy. And I think we have to, as we prepare young people and others for adulthood and for parenthood, we have to come to the recognition, we have to understand that in order for young people to assume that responsibility, then before they leave under our roofs, we need to allow them to demonstrate that they have reached the point that we are figuring that we are training them for. And I think that will, in traditional Barbados, call for a change in mindset. It will call for a change in that mindset, like I indicated earlier, which says you cannot be an adult if you're in the house with your parents who are the adults. We have to change that because our young people, before they go out on their own, need to demonstrate. And we need to allow them to demonstrate that they have grasped what it means to be an adult and what it means to be a responsible citizen in our society. We cannot leave mentoring to media. We cannot leave mentoring to television, because as much as we say yes rather than I, we will still end up with people taking on mores and value systems that are not ours. And so language may change, but the attitudes will be the attitudes of, it's only about me. Attitudes of selfishness, which are not the traditional Barbadian attitudes. Barbadians are known to be sharing people, caring people. If we allow our children to be mentored by television, then we run the risk, and I'm not saying that everything on television is bad, but we run the risk of our young people inculcating values that are not either the traditional values of our country or are desirable values for the building of a good society. Now, Mr. Speaker, I also believe, and this is in connection with what I talked about, young people not being able to demonstrate that they are becoming or have become adults. Oftentimes, young people are discriminated against because they are young. What do I mean when I say that? The matter of being seen and not heard is, in my view, discrimination. We often talk about age discrimination based on persons with hair more of your color, Mr. Speaker. But I believe that you can discriminate against younger people as well. Because young people are people. They have a voice, they have a view. Those of us who interact with children know that very often their view does not concord with our views, but they have a right to be heard. And we have a responsibility to interact with them, to engage in conversation with them, rather than what I call discriminate against them because they are the little ones to be shunted aside, pushed aside, not heard, not allowed to speak. And then we expect them to be valuable, responsible, contributing members of a society. All I've said, Mr. Speaker, for the past few minutes was really to say that a lot of what we do, a lot of our actions are not in concert with what we want out of our young people in society. We end up in a situation where sometimes we are in fear when we see certain people. We believe that there is this newfound bent to doing wrong. And I think we have to be careful not to fall into the trap of what is sometimes called news cycles. We see it in the North American system, where every time there's a school shooting, there is talk about gun control. Then after 7 or 10 days, that goes away and something else becomes the order of the day. We have to recognize that the issues of developing a society, that matter is a matter that doesn't end. And so in spite of all the other things that we do, we have to recognize as parents, as adults, as leaders, that we are building a society. Building a society means adding capacity to all members of that society. That includes our children, our young people, the very ones who we see facing the criminal justice system on a all too frequent basis. We have a responsibility, and Mr. Speaker, I am calling on all of us as leaders, I am calling on all of us as adults, I am calling on all of us as parents to accept the responsibility, to own it, to see children and young people as our own, whether or not there is any biological relationship. We have to see all young people as our own. And if we are interested in building the just society that most of us say we are, then we ought to really put our shoulders to the plow and ensure that we transmit from our generation to succeeding generations those values that will add to the building of a good society, those values that will add to the development of a cadre of young people who can take over from us in leading this society so that we do not have to depend on a criminal justice system to keep our society going and to keep it functioning in the way that we would want. And so with that, Mr. Speaker, I want to support the bill before the House. I believe that as we move forward into our term in office, you and the country will recognize that we are on a mission both to use our system of laws to maintain order in our society, but at the same time, we are also on a mission to use other methods, non-legal methods, methods that speak to our understanding of our responsibility to build the just society that we have come to office to build. I'm obliged to you.
Honourable Member for St. Joseph.
Mr. Speaker, let me thank the member for St. Peter for his contribution on this matter. I beg to move that this bill be read a third time.
Second time. Second time.
I did that already, and y'all said aye. I beg to move it be read a second time.
The question is that the aforementioned bill be read a second time. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that this bill be read a third, that you do now leave the chair, and that this House resolve itself into committee for further consideration of the bill.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
This House is now in committee.
Clause 1.
Beg to move that Clause 1 stand part.
Question is that Clause 1 now stand part. All those in favor say yes. All those against say no. The yeses have it.
Clause 2.
Mr. Speaker, I beg to move that Clause 2 stand part.
Question is that Clause 2 now stand part. All those in favor, please say yes. All those against, please say no. The affirmations are in the
Mr. Chairman, I
majority.
beg to move that you do now report to His Honour the Speaker the passing of one bill in committee.
Question is that I should report to the Speaker the passing of one bill. All those in favor, please say yes. All those against, please say no. The affirmations are in the majority. Thank you.
Will be read a third time.
Questions that the aforementioned bill be read a third time. All those honorable members in favor, please say aye. Those against, please say no. Meeting the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited as the Offences Against the Person Amendment Act 2019.
The questions that the aforementioned bill be passed and so cited. All those honorable members in favor, please say aye. Those against, please say no. Meeting the ayes have it. This bill is passed and so cited. Huh? Passed the bill already.
Revert to announcements by your Honourable Speaker.
Message from the Honourable the Senate to the Honourable the House of Assembly. The Honourable the Senate has the honor to inform the Honourable the House of Assembly that at its sitting on Wednesday, 27th of November 2019, the Queen Elizabeth Hospital Amendment Bill 2019 was amended in the terms as cited below. In Clause 3, subsection 2, the words "the Chief Operations Officer" and the following executive directors were deleted. Additionally, the words "Chief Operations Officer" were inserted as a new paragraph A, therefore requiring a consequential renumbering. In Clause 4, in the new section 9A, paragraph 3, the word "may" was deleted and the word "shall" substituted "therefore," and the words "as the minister may determine" were inserted after the word "conditions." In the new section 9B, the words "without the approval of" appearing after the word "removed" were deleted and the word "by" substituted "therefore," and the words "without the approval of the cabinet" inserted after the word "minister." Section 9B should now read, "The executive chairman shall not be removed by the minister without the approval of the cabinet." In Clause 5, paragraph 1, subparagraph 3, the words "may" and "a member" were deleted, and the words "shall" and "chairman" respectively substituted "therefore." At paragraph 1, subparagraph 4, the words "in addition to the executive chairman" were inserted after the word "shall" and before the word "comprise." And subparagraph C was deleted, therefore requiring a consequential renumbering of subparagraphs. And the Honourable the Senate transmits the amended bill to the Honourable the House of Assembly, inviting concurrence in the amendments to the bill, dated the 27th day of November 2019, signed the President.
Revert to papers.
Honourable Member for St. Michael Southeast.
I am commanded to lay the duties, taxes, and other payments exemption Bank of New York Mellon Corporation Order 2019 and the results of the external debt exchange offer.
Revert to government notices.
Mr. Speaker, I beg to give notice of a resolution to seek the concurrence of the Honourable House of Assembly in the amendments made by the Honourable the Senate to the Queen Elizabeth Hospital Amendment Bill 2019.
Revert to government business, sir. Order number 13, in the name of the Honourable Minister of Health and Wellness, to move the passing of a resolution to seek the concurrence of the Honourable the House of Assembly in the amendments made by the Honourable the Senate to the Queen Elizabeth Hospital Amendment Bill 2019.
Honourable Member for City of Bridgetown.
Mr. Speaker, I have examined the amendments made by the Honourable the Senate.
Continue, Honourable Member. Continue, Honourable Member. Disregard what you're hearing as an aside. Continue, Honourable Member. Disregard the aside.
Thank you, Mr. Speaker. And there are no objections from me in relation to the amendments made. And so I do move that the Chamber concur with those amendments made by the Honourable the Senate.
The question is that the aforementioned resolution be passed. All those honourable members in favor, please say aye.
Aye.
Those against, please say no. Meeting the ayes have it. The aforementioned resolution is thereby passed.
Mr. Speaker, with that, we've come to the end of today's sitting. I beg to move that the House be adjourned until the 17th of December
17th?
at 10 a.m.
17th.
17th of December, Tuesday, the 17th of December at 10 a.m. Yes.
The question is that this honourable chamber be adjourned until Tuesday, the 17th day of December 2019 at 10 a.m. in the forenoon. All those honourable members in favor, please say aye. Aye. Those against, please say no. Meeting the ayes have it. This honourable chamber stands adjourned until Tuesday, the 17th day of December 2019 at 10 a.m. in the forenoon.